Nice. Okay, good start. Okay, where am I holding? First of all, welcome everybody to our beautiful class, Mr. Shem. I would like to dedicate this year Leila Nishmas L'chol Yehuda Releb Olav Shalom Ben Duben Sheikhya, whose Yarchei was yesterday, based on Achmav, and as well to the Leila Nishmas Minya Esther Bas Shneir Zalman, whose Yarchei is going to be this Friday, Heyman Achmav. So the goal tonight is to go through some of the Yesodis and pretty much raise the awareness that there is when it comes to, you know what, I want to record on my phone also, just in case. So again, the goal tonight is to raise some awareness in the sugya of Harkois, which is also known as Harkois Shel Akum or Harkois Shel Goyim, sometimes Harkois Shel Kutim, whatever you name it, is the sugya, the subject about the prohibition of going to a secular court when either parties are Jewish, as we'll see. So, Baruch Hashem, we have some time. I mean, this sugya, you can spend weeks learning the whole sugya to get to grasp all the details, and we'll try to get as much as we can, especially when you get the Yesodis, so that we can grasp a little bit about the seriousness of the issue and know some of the klalim that applies in this aspect. So, if you have any questions, try to leave them for after each subject that we go through. Also, if you feel that I'm talking too fast, let me know. I'm going to try to slow down. I have a nature of speaking very fast, especially when it comes to the Torah, and especially when we have a lot to cover. There's a lot to unpack. I would like to first start with the Vart that I heard B'Shem Rav Heller from the Vilna in Heinz, where he said once by Fabringen, he usually Fabrings it as Kislev. One of the Varts that he shared is that we have the four halakim of Shulchan Aruch. We have the Chaim and Adiyah, Chesed Mishpat, and Even Ezer, or Even Ezer, Chesed Mishpat. Chesed Mishpat is the last section. So he said that the Chilek Chesed Mishpat is actually only not from Yid. Why? Because from Yid, you shouldn't have any fights, you shouldn't have any cases or any problem with another Yid, and you should try to get it solved without having to look into the halachas about Chesed Mishpat when you have a monetary dispute between one another. And this is also kind of represented in I saw this in Pitzur Shulchan Aruch, and he has one Simon Kufpei Aleph, where he brings all the details of Leil Tein Venitan, which is a subject in Shulchan Aruch. It covers many simanim, but Shulchan Aruch comprises, and he put everything into one Simon. So he starts the Seif Aleph by saying that when Kashanafal Ben Shnei Adam is a sichuch, when you have to any person, any sort of dispute that he has with another Jew, between two people, that it's appropriate for them to try to get to a solution and resolve a settlement, or there's even a better word, I forgot which one it was, legally speaking. It's not a settlement. Forgot what it was. So you don't bring it to a court even. So and you can even give up some of your claims or whatever, in order to avoid the issue, compromise. Yeah, to avoid the issue of getting to a basin and dealing with one another. This whole scene is actually talking about what's brought down in Chesed Mishpat, that you always try to do a shara. Anytime you have a blessing, you try always to avoid the actual have to have a blessing. But still, he had some words here that appear to be the same word that Rabbi Heller was saying, that if you're from a Yid, you should try to as much as possible not to get into a trouble where sometimes troubles come up. You know that it's not if in an ideal world, the best would be for people to try to avoid the whole Chesed Mishpat in general. But the Maisa, we know that things are not perfect, and we need to know the halachas because issues do come up, and the Maisa, we need to know these halachas, and it's also part of Torah. Just two nekudas before we start into the sugya that are relevant, that I was getting some questions from people before I started class, some general interesting questions. And again, this is question number one is, does the prohibition, which we'll see, does it apply also when you have a case against a non-Jew or not? Is it only when you have a Jew against a Jew that you're not allowed to go to secular court, or does it also apply to a non-Jew? And the answer is yes, it does also apply to a non-Jew. That follows, when it comes to a non-Jew, most Jewish people now live in areas where court is a secular court anyway, so we end up following the halachas that allow you to go to a regular court in order to have a case with a non-Jew. But technically speaking, essentially, the prohibition still applies to a guy. It's not just between two Jews. It's any time you have a Jew in either party. There's a plaintiff or the defendant. So that's number one. It's also connected to the idea that I was mentioning earlier before the shir started, that it's connected to the 9 days. That it's brought down in the Gemara in Tainis brings down. It's brought down also halacha. The prohibition, not the prohibition, that a person should try to avoid having a besting with a guy during these days, mainly the 9 days. Some people say even throughout the whole 3 weeks from Shavuos B'Tammuz. Some even say till the whole month of Av until Rosh Chodesh Elul. So it's just connected, and we're going to see also inside other connections that I found to get the times that we're living, the 9 days, as well as the situation in Eretz Yisrael. And number two, the second question that I got, it's also a general question, is how does Dinu D'Machus Dina play with the idea that we're learning here? Isn't it a law that says that the Dinu D'Machus Dina means whatever the law in a local place you have to follow? So how could that match with the law that we're learning here? You're not supposed to go to secular court. So the basic answer to that is that there are two different categories, so to speak. There is the idea that when it comes to the laws, the local laws of the state or the country you have to follow, that's Allah. But when it comes to monetary or financial issues between two parties that are more like a private situation or a problem, in that case, the idea of not going to secular court applies. Okay, so we're going to start with page 1. I divided the class into 10 sections. As you'll see, there are 7 pages, so we have an hour. It's like average less than 10 minutes per page. So let's go. So first we're reading the Mokkeh. What's the source and a little bit of the reason? The prohibition of going to a secular court, bring another Jew to a secular court. So the Gemara says in Gittin, I'm going to read it inside. Most of the classes will be reading inside. I'm going to give some insights to what we're reading. Rabbi Eskinazi, Rabbi Yosef. So Abaye was came to Rabbi Yosef. Rabbi Yosef was doing some gittin. He was answering people some questions and dealing with some people that had to give Jewish divorce. Amar Lei, he said to him, but we're hedged. We're not we're what's it called? I forgot the word. We're not proper. We don't have the proper degree of knowledge to deal with this case as the Taina. It says in the Brayso, the Mishnah, it says in the Brayso, call Mokim Shat to Mitzvah Gurias Shalei. So these are the words I highlighted. You cannot deal with these cases with them, with the blessing of a Deutsch, like it says in the Pasuk, the beginning of Pasuk Mishpati, Ve'ela Mishpatim Shadasim Lifneihem. The word Lifneihem comes to teach you. So basically, he's trying to learn the second part, which is about the prohibition of regular people dealing with cases. You're supposed to have some knowledge in order to be a dayan and be able to qualify as a besdin. But in between the lines, we also learned the halacha that lifneihem, the word lifneihem, the pasuk also teaches us the lifnei goyim, that you're not allowed to go to a besdin of goyim in order to deal with any dispute. Later on, we'll see if this mitzvah, this issue has a din deraisa or if it's only midrabanan, as we'll see. Number 2, Rashi, Shmois Chavalef Aleph. That's Rashi already in the Chumash. He brings this din in the word Lifneihem. I think it's the third Rashi in Parsha Mishpatim again. Rashi says, the Kiddush is that even if you know that the guy is following the lachas of Torah, let's say they're fully keeping all the rules and all the klalim that you have to keep. Nevertheless, it's still forbidden. You cannot bring to their courts because the person who does so, he's doing chilul Hashem, and he's also a miyakar shem avodah shpicha, is sort of a part of avodah zarah. Shenamar ki loket tzedenu tzuram v'vinu p'lilim. Says in Pasha Zazino, k'shevinu p'lilim zeh way they do it. When our enemies are ruling us, so then it's edus leilu to yosam, which means that we're giving power to their avodah zarah. So
also yesterday we're learning about shootings.
I mean, we're going to find a lot of, even when I get ribs also, there's many connections when it comes to Cheshamish, but there's things that apply to all those.
Going. So one of the things about shootings with the law is also
Whether it's possible with the Zara. I want to point out that although here it's connecting directly to the Zara, la halacha, it doesn't matter if the guy is an Oved Avodah Zara, like a Christian, or even if it's a Muslim, who's technically speaking, there's a whole discussion if it's a or even if it's a guy who is a atheist and he doesn't believe in any God, nevertheless the prohibition still applies. Okay, also you see that then Rashi quotes the Midrash Tanchuma. We'll later see inside interesting things about this Midrash. Then you have number 3 on this page, source sheet. Midrash Tanaim, Dvarim Tazayin. It says the small phrase Kol ha'olech ladin etzel umes olam ki'ilo oved avodah zara. Now he compares that whoever, even a Jewish person who's now going to a secular court, is as if he's serving avodah zara. Number 4. Now the Rama brings halacha in Hilchos Sanhedrin, Perek Chavav, halacha Zayin, which is the last halacha of Hilchos Sanhedrin. There's so many prokim, and this is the last halacha. That's how the Rama finishes that section. Kol adon b'Yarchei Kallah b'Arkash Elhen, afal pi shehoyu b'dineim k'dinei Yisrael. He's a Rasha. He calls him a Rasha. V'cheilu cherev v'kidei v'hirim yod b'teres Moshe Rabbeinu shenemar. And it's as if he is going against the Torah of Moshe Rabbeinu, like it says in the pasuk, like we mentioned already. Then now the Rambam adds some details. If it's in a case where you're living in a place where you're under non-Jewish sovereignty, and then the person who you're having a case with, he's being stubborn and he doesn't want to come to Din Torah. So in that case, it's penalty done. You should go to Bezin. If he doesn't want to come, later the choose Bezin. In that case, in that specific case, we'll see more details later. When you're dealing with a person who's stubborn and he doesn't want to accept the case of a Bezin, so you can go to a Bezin first, and then you get a permission, you get a reshus to then allow you to go to a regular court, regular non-Jewish court. We're calling here regular. Okay. Then number 5, interesting also to point out from Rambam, which is in the beginning, when Sefer Mada, there the Rambam is dealing with the halacha about nidui al-mevazin tamid chacham. Nidui is we put a person under a ban for being disrespectful to a talmid chacham. So then the Rambam brings a distinction between if depending if it's a talmid or if it's the Rav. That if it's only if there's a student that he has somebody who's being disrespectful to him, he's allowed to give that person a nidui. But the Rav, the rabbi, not necessarily, he can say that no, I respect that person. He doesn't have to be under my nidui. Then the Rambam brings there are exceptions to this rule, and there are many cases when nidui applies even if one person, one Jewish rabbi of a community decided to put a ban on a person. There are 24 cases when every Jewish person in the world has to also follow that nidui that this rabbi put on such person. So one of the 24 cases that he brings here, the number 9 is a test. Here we're talking about if a person goes to testify, you're going as an aide on a case that's happening between 2 Jews, and this is happening in a secular court. So even the person who's going to testify, he's placed under a ban. So we'll see here a little bit about the seriousness, which we're going to see more later. I just want to bring here because it's the Rambam in the beginning of his Sefer Mishnah. Number 6. So now it's Badam Halacha, and the Mechaber brings the Shulchan Aruch. The Torah already brings Simon Chavav. The Mechaber writes Simon Chavav Seif Aleph. We're going to see more in depth later, the next page. But he writes just to bring here also the Don B'fnei Yaakov Be'akash Elahem. Like we mentioned already in Rashi and in Rambam, that the Chiddush is that even if they're following all laws of Torah, it's still forbidden. And even if for whatever reason both parties are in agreement, they don't mind going to a secular court, it's still forbidden. Even in that case, you're not allowed. Like the Rambam said. Okay. Finally, number 7, I wrote down here, which is important also, that in Pashas Shoftim, in Dvarim Perek Zayin, we have a few psukim that bring the mitzvah, in addition to the prohibition of going to a secular court, we have a mitzvah min haTorah. The Rambam actually brings this as a sefer mitzvah, mitzvah kuf ayin dalet. There's a mitzvah min haTorah to go to a bezdin. Anytime you have a dispute, there's a mitzvah min haTorah to go to a regular, to a Jewish bezdin, and to follow with the psak that they give you. And these are the psukim. I just quoted them here for reference. Page 2.
You can also ask the base team to allow you to go to a secular court, right?
Sorry?
You can also ask the base team
Yes, as we already mentioned briefly about this the exception, and we're going to see more details later on. In which cases you're allowed to.
Right. Which means here, the one that we mentioned here was about when there's no point of taking it to a basic because you guys had a list.
Yeah, but even in the case, as we'll see, you still have to first go to a bezin to gather the truth. In most cases, and we'll see more details later. First, we're going to be getting some Yisudis at Varim and the general prohibition. Page 2. This is the last source of Mekoros and Tamim. This is the Medrash Tanchuma that Rashi quoted in Mishpat and Gimel, and we're going to read it in sites. There's some interesting things. So base there it says Minayin lebali din shel shesh lahem tin zaim ze she yoidim sheuma is done in resetim kidin sol also is dakik bifil lifneim. How do we know that it's forbidden? Talmud Lema Rashi doesn't lifneim. It says in a passage that we mentioned already many times. Lifnei sal v'le lifneim zeh. Now I highlighted this. You call me shemaniach dayan Yisrael v'hilik lifneim zeh kafir b'kadosh baruch hu tchila v'charechein kafir b'torah. Any person who sort of forgets or leaves the Dayani Israel, the judges of Israel, and he goes to a secular court, he's going against the Eibishter first, and then he goes also against the Torah. As we quoted earlier as well. Now he brings a mashal. This is a famous mashal. I don't remember where I saw this or heard this, but it's a mashal that's brought down in many places. It's a mashal of you have a sick person and a doctor comes to visit him and check him. He tells his family, you can feed him and give him to drink whatever he wants. Don't take anyway, don't deny anything to him. He can eat and drink whatever he wants. Now he goes visit another sick person, a second person. He tells his family, tell this person not to eat this, not to drink this. So we see two different cases. So they approached the doctor and asked him, so basically the families ask, what's the difference? Why do one patient, you're telling him that he can eat and drink whatever he wants, and the other patient, you're telling him you can't eat this, don't give him to drink this. So he said it's very simple. The first patient, he's dying regardless. So let him eat and let him drink whatever he wants. I don't care. So he can eat and drink. The second one, however, he has a chance of living. So in that case, I told you not to give him and not to drink to him. So the nimshal is as follows. That the nimshal is the goyim and us. That when it comes to the goyim, regardless of what they do, they're not going to get anything. So Hashem says they can do most things. Hashem says, but they can do whatever they want. When it comes to Bnei Yisrael, we have a chaim, so to speak. We have a life that we need to take care of that. So because of that, Hashem gave us Torah mitzvahs and many chukim, etc. So it's interesting that the mashal is brought down here, specifically bringing it to the din of Arkais. I remember seeing this mashal brought down in other places as well. Finally, in the last piece of this Mekoros we bring here, which is connected now to the period that we're finding ourselves, the 3 weeks and the 9 days already. If you follow this halacha properly and you go to a regular, proper Jewish bezin and you don't go to a secular court, Hashem promises that He's going to build us the Beis Hamikdash, and consequently, the Sanhedrin are going to sit in Beis Hamikdash. We're going to have the supreme high court of the Jewish people. Like it says in the Apostle, these two psukim are the last two psukim of this week's of Torah, Pashas Dvarim, Shabbos Chazoin, in Yeshaya. So it says in this pasuk, Veshiva Sheftach Kevarishena, Tzilim Sheftipad, etc. And as well, it's written, Koyamar Hashem Yishmenu Mishpat Vastoka Ki Kroiva Yeshuasi Love V'Geime. Right? That when you keep the mishpat and you do tzedakah, Kroiva Yeshuasi Love, this is also this is the Haftarah that we read on every fast day by Mincha. This Hashem, things of Torah, in the middle of this pasuk is found in the middle of the Haftarah. Okay, so that's why I quoted this Medrash Tanchuma. Otherwise, I would just leave it. But when I quoted Rashi, and I saw that the Tanchuma is talking about Yonah D'Yoma, I decided to add it here in the list. Okay, base. Pretty dinim. Let's go through some of the details of this halacha as brought down in the Shulchan Aruch. So we already quoted a part of the seif, but now we're going to bring the first two seifim of the simon. I believe there's four seifim, but we're just brought the main two, the first one, two ones, because it has the main halachas in this case. So the Mechaber writes, also lodem lifnei deyane akum ve'akos shelhem pidus moshe kavol sonim boy afilo bedin shedonim bedin exo, as we already mentioned, afilo nisatsu based baladin lodem lifneim also. So we already brought the two chidushim. It doesn't matter if they're following the Torah laws, and it doesn't matter also if both parties want to go to the secular court. Mechaber brings this Allah as we already put it earlier. Now that Rema adds here, the Bezdin has the power to place him under a nidui or a chedem, ban, until he excludes himself from going to the secular court or taking his opponent to the secular court. We also place a ban to a person who, somebody who takes somebody, what does this mean? Okay, even if he doesn't know. Oh. I forgot what this means. Anyways, okay, which means here that even if a person is not bringing somebody to secular court, but he's using non-Jews to force him or to persuade him or to oppress him in order to get his money back, let's say, so to speak, he could be placed under a ban. This should be also
supporting some people.
Yes, that's the word. Even somebody who supports somebody who goes to a secular court, let's say he says, go, do this, I will give him advice. In that case, you can also place a cherem on that person, even if that person himself is not going to secular court. And then he adds later on, that actually could feel like the Yaakov, if you're having somebody who's hiring non-Jews to force a Jew to go to secular court. We'll see later on, the Rama brings that if a person ends up going, let's say somebody takes his opponent to a secular court, and now he was found guilty and he has to pay. So now he wants to go back and bring him to Bezdin, because maybe now he's going to be found not guilty, meaning he was found guilty in the secular court. So now he says, you know what, let me try my luck in the regular Bezdin. So in that case, the Rama says, we don't accept him. We say that he's already lost his chance and he did something wrong. He's going to live with it. The Yeshayim, however, some hold that it is talking like that we do listen to him in Moshe God unless they gave a hefsed to the opponent himself. Sometimes he has to pay the city or whatever the case is. The Rama says that the first opinion seems more correct, which means that in any case that a person files a lawsuit against a Yid in a secular court and he loses, we do not accept him now to come to Bezdin to try his luck and see if he gets the money back. Seif base, the Mechaber says, in the case that we mentioned earlier, where you live in a place where you're under the rulership of non-Jews, and your opponent is a stubborn person. You should go to Bezdin. If he doesn't want to come, you can now get the shoes from this Bezdin. Now you can go to the secular court and present your case. The Rama brings now the Bezdin, even the Yonim themselves, the Bezdin, they have the reshus now to go to the secular court and to testify on whatever parties on behalf on them to show them that he's obliged to pay. And this whole din that we mentioned, that a person is allowed to go to the secular court after getting a reshus from the Bezdin, only applies when the other party really doesn't want to go to the Bezdin. Also the Bezdin on shoes, but if we see that he's willing to appear in front of the Bezdin, in that case, the Bezdin will not give the plaintiff a harsha, a what's it called?
Permission.
A permission. Thank you.
Will the Bezdin give permission after the din? Will the Bezdin give permission to go get it enforced by a secular court? They don't have the power.
Well, yeah, we'll talk about that. We'll talk about that. Great question. It's very relevant.
Yeah.
Because at the end of the day, many times when you go to a bezin and the bezin pasking something, not necessarily the other guy's going to do it. And if you don't, some people don't care.
Supporto dell'amore.
Where?
Non è dell'amore sospeso.
Yeah. That's something else. We're asking here he's asking if let's say you go to a bezin, person goes to a bezin against his fellow man, and this guy turns out to be chayav. Question is, can you go now to a secular court to enforce the psak din of the bezin? That's something else.
So these days,
What we're gonna bring later, yeah.
these days you have but the dinim usually have some kind of in America more than here. America, for example, psak din of a bezin has a.
Oh yeah.
I mean, if it's done properly.
In all states?
Here, I don't know. Here it's considered arbitration.
Yeah.
Right.
So that arbitration it can be enforced by court arbitration.
That was the word I
That's
was looking
law
for,
study.
arbitration before.
Yeah.
So in America, I think it's stronger.
What's arbitration?
Arbitration.
Is before you actually have a case.
Shara.
Arbitration is.
It's a settlement.
No, arbitration is a private court.
No, I understand. I'm saying in Hebrew, what arbitration would be, בוא נגיד, זה לא כמו דין, זה לא משפט. אלא זה לפני משפט שיושבים ועושים
No, you actually do through it. It says through a but you
The parties by agreement can choose any.
Oh, legally, yeah.
Well, if I have clients who don't want to go to court, they can say, well, we'll choose this lawyer to be the judge.
Yeah.
And you need an agreement, and if you have an agreement, then
In a real estate
whatever
contract,
decisions you render, you bring it to court. So if we set up a basement.
Yeah, so that's what it's called zavla. Each party takes one dayan, and then you have a third dayan. They sit together. It's even before the din. We started this with the Kushon Aruch. The Kushon Aruch, when he brings the Sif Aleph, is that we always prefer doing that according to Allah. We always try to avoid a real din of the real bezin. Okay, Gimel. Let's go through it. Page 3. Gimel. Chumra Seisum. Now we're gonna go into detail of what the severity of going to secular courts are, and we're going to bring some interesting details. One, like we mentioned earlier, we weren't sure, so now we're seeing that according to most poskim, the issue of going to a secular court is midiraisa. And some want to say that it's only the Rabbanan. We have a pasuk. The pasuk is only a smach, but according to most poskim, is the issue deraisa. 2. So we already brought this before. Had is Rasha or Kilu Khara Vegado Mahani Biad Ayad Betarmishel Ben Al-Shanam, Madam Kamizrael, Nambam, Chufanarov, etc. Ubiro Achrenim Esadvarim. The Achrenim explain what does this mean that a person is considered Rasha as if he raised his hand against Moshe Rabbeinu. Shemara Kilu Tudas Moshe Ina Emes. He's showing as if for him, Teras Moshe is not true. And now he can't, because Torah is not true, so he doesn't want to go to Bezin to find out what the din is. Now he decides he wants to go to secular court because in his belief that they have the proper intellect and logic to decide who's right and who's wrong. 3. Rabbeinu Bechaya says in the beginning of Parshat Mishpatim, we're going to read the quote. He says that it's an avera, that it's comprised of many averes. And then he continues saying, he says that it's even more strict than murder. Because it includes stealing and also Chilul Hashem. It's definitely Chilul Hashem because at the end of the day he's giving the covet and honor to other people than to the Torah that we have. And Gazel, he considers stealing it because it's not going according to Torah, and even more so he adds, and we're going to see also later more that bring this part, and it also applies to ribis, by the way, that in many instances we say that ribis, when a person charges ribis, is even worse than stealing, because when a person steals, he knows he's doing something wrong. So he still has sometimes he goes to sleep, he has a bad conscience, he's doing tshuva, he wants to ask mechila. But when a person goes to a secular court, and when a person charges somebody ribis, for instance, In that case, he doesn't know he's doing something wrong, and for him, it's like it's the right thing to do. I went to a court; they decided I have the right to collect the money from this person, and now he doesn't even have the regret. He doesn't have the remorse. He doesn't want to even ask mechila from the other person. So it's even more strict in terms of that. Number 4, shutar adbaz, helik dalet in kofaf. The punishment chamor yosem in a gezel v'laveshek chamos kol echad meilu efshel sheyas tshuva kim shegazet. Same word that we were saying. Aval zeh choshev shezaka b'din v'huzach v'nim tzashim shomayim mischal el yadoin ve'oid shegoyim l'shchina shetistalek v'yisrael. Person who does this, he's committing that he's affecting that the shchina is leaving Am Yisrael le'neinu. If shenoisen koyach le'kel achad, because he's giving the power to other deities, so to speak. 5. Now we see a loss of the Zohar. This is a translation. Targum. Means any person who goes to a place where they do their dinim, their judgments, not according to the Bezdin of Israel, he's a sinner. Okay, this is just a few of the most example places where we speak about the severity of the issue. Now in the next few points, we're going to bring some more details that are connected to this. Number 6. The law also follows if, or for whatever reason, 2 people went without permission from a bezin, and they went to secular court, whatever they decided, whatever they paskin is not considered a din. And therefore, the lochein, thus, psak din, in those cases where the psak din that they got in the secular court is not according to Torah. For example, in a case where they, for whatever reason, according to Bessie, the person wouldn't be chayav, but now he's chayav. So the person who takes the money is considered a gazan, is considered a thief, as we already explained. Because according to Torah, the defendant is free; he doesn't have to pay. The Allah also goes for the extent. There's many places in Allah we bring this what they call measurement, that we see that even if the person uses that money now to be mekadesh a woman, the woman is not considered mekadesh because it's considered gazel. The moment you gazel, you can't be mekadesh a woman. But because it's considered stolen money, he also has the chiyuv to return to the defendant. So that's just general recall. Number 7. Now this is an interesting piece of a letter that the Chavetz Chaim wrote. It's brought down in the Sefer Zichron Nechiruv in a page of Zayin. So he says as follows: the punishment for a person who does this means he goes to our Koishal Goyim is very, very strong. The Mekubalim write that the punishment for a person who goes to a Koishal Goyim is that he gets dragged by a dog who's barking. This is also hinted in what it says in Torah in this last week's parsha, which is Matais, and then if Matais Veikra Law, Neivach Bishmai. So what the law, Lamed Hehu, Loshitiv is Loshin Hara. Here the whole letter is talking about Loshin Hara and also Koshel Goyim. Neivach, Klemashem is Galer Bekelev Neivach, that he's being dragged by a barking dog. So that's his Einish. Stam, an interesting piece of this letter that I found, so I just included here. And then finally, number 8, we have a minor from the Rebbe. We have the Ksav Yad. It's printed in a few churas and also in the Tzfar Chabad. But the Rebbe writes as follows: Amarti Boror lekol sheshalom b'dem. I already told to anybody who asks me on this regard, shekol zeh tzarich li'ez ach v'rak l'di rabbonim. That this subject, this matter, has to be specifically through rabbonim. Noisef aleika shekin hu al pi Shulchan Aruch. This is in addition to the fact that this is also according to Shulchan Aruch. The Rebbe is saying I also suggest, and my opinion has to be through rabbonim. Harei im rachamana litzlan yagil al koyes. But if for whatever reason he goes to a secular court, and you can't imagine and you can't measure. That's the word. The hezek, the damage that this can cause. So first of all, to the person who began this whole case of bringing this the specific case to this whole episode of taking this case to a Jewish, to a non-Jewish court. Okay. So hopefully we got some sense of what the Chomer Advarim is. Now we're turning to page 4.
Well, what's with the Israeli court?
We'll talk about it. Excellent questions. Dina shalaylecha dun bar kois. Yeah. So number 4, what's the din of a person who, for whatever reason, he did go and he went to a secular court without getting a shusar on best? So number 1, we're holding on page 4, Daled 1. Who began moiser, that a person who goes to a arkois, he's categorized as a moiser, and therefore such a person, you cannot use him for any time that you need a kosher aid. And also, we don't rely on, he can't do any shvuah, he's not allowed to promise whenever in Allah they have the lachas of shvuahs. Some say, that if for whatever reason he was mistaken, maybe he thought that it was permitted to go to secular court because in fact the defendant owns him the money. In that case, some say he's not possible edus because he didn't do willingly and he didn't know the basis, so to speak. But if it's in a case where people warn him, do not go to a secular court, this is forbidden. According to everyone, he's possible edus in the shua. Okay, interesting din. Number 2, a poiskim the poiskim also they enumerate and they bring other examples of things that a person who goes to a secular court is not allowed to do. Number 1, possible liksiva stam, he's not allowed to be a sefer or sefer Torah tefillin and mezuzahs. Number 2, possible shchito, he's not allowed to be a sheikhet according to halacha. Number 3, ena yachol is shatz, he cannot be a shlich tzibur, a chazim, bifrat b'yam b'noim, especially in the high holidays of Rosh Hashanah and Kippur. Number 4, ena ela latera, you're not allowed to give aliyah latera in shul. And number 5, so I want to add that the chain letzarfoi leminan lechal davar shebiktusha. You can't even count it for a minyan or anything that you need a minyan for davar shebiktusha. So we see here also a little bit of the seriousness, but we're talking mainly about what's the deal with a person who goes to a second court. Number 3.
It's famous Moiser.
Moiser, yeah. Yeah. I mean, Mesira applies to many other. We're going to talk later if we have time a little about other examples. But he's the categorized as Moised also, because at the end of the day, he's going to court. And when you have to bring a case to someone else, against someone else, you have to. 3. The person also can be placed under a ban. What's another word for cherem in English? Ostracism.
Excommunicated. Ostracized. It's not really right.
Ban. So as we saw, the Rama brings it before, another credits. Number 4. Also, the Yehudi afilule ayin al chavera she'it ba oisem be'arkoyes. A person cannot even pressure or influence a person to take him to a secular court. A person who does that is also possible, even if he's not the one doing. 5. You see the word shara here, that not only just doing a real case and their secular court is forbidden, but even to do a shara, to do a arbitration or whatever you want to call it, is also forbidden. Shara kuriyadin vein ladun fneim. The mice in the halacha, arbitration or this case is also considered din. Vein ladun fneim. The halacha is they can't do any business, any din in front of them. Hey, get that arkois. So now we're going to go into some of the details of what does it mean arkois. How do you define arkois? In which cases is permitted, in which case is forbidden. So number 1, gam kol arkois shitufis shedina shelei dinton afilihim ima sheftin him Yehudim dina karkois l'chol davar. The klal is that even if all the judges are Jewish, but they're not following the din Torah, it's also considered arkois in this regard. And I brought here a klal that you have 3 cases. It's basically 2, but you can make it to 4. Arkois goyim sheposkim b'hem fidin goyim. It's the regular case. You have a secular court that is for non-Jews. That's no question that it's forbidden. But even arkois goyim sheposkim b'hem fidin Torah, even if you have a secular court that for whatever reason they follow din Torah, is also forbidden. We already mentioned that many times. And number 3, arkois Israel sheposkim b'hem fidin goyim. If you have 3 Jews, you have a bezdin that for whatever reason they're not following the din Torah, they're asking according to Dina Goyim is also forbidden. Call Elu Dinam Karkois L'chal Davar. In all those cases, it's considered arkois and it's forbidden. Now, it's interesting keta from Shut Shalos Chuvas Tzitz Eliezer, Kedekul Beis Simon Pei Beis, he writes as follows: "It is there." He's talking about here when you have a yid doing a bezdin without following the Torah rules. In that case, Gorua V'Goy is worse than a goy. Why? Shagoy ena metzuva ladun dafka b'din Yisrael, but Yehud is there. Afal b'shechata Yisrael who metzuva al kol din Torah. Zembor reposh shifting halal or arkois him the chol davar v'chalo lechatzlom made him yad b'teres Moshe or marati acharisa shel mechazek oisem. So he's saying here that it's in fact when you have a court of Jewish people who are paskening dinim not according to Jewish law, in that case it's worse than goyim who are sitting and just doing what they are paid to do. Right. Number 2, the lochein, and therefore based on everything that we said in number 1, kol sugi bati mishpat az lochim mitzuyim kayim b'Eretz Yisrael. Rabbi Shochat, answering your question. All the bati mishpat that are local bati mishpat that we find nowadays in Eretz Yisrael, dinam karkois, they're categorized as arkois. V'yisur chomer lelechas lodum b'hem l'lilit l'shuz mi'bebi based in tzedek shel gimel diana, and it's a outright isur to go to them without first getting the shuz from a besin of 3 dayanim. I just want to add, I wrote a star over here that this is according to most poskim. Most poskim hold like that. And in Eretz Yisrael, unfortunately, nowadays all bati mishpat, as they call, they have the din of arkois, especially because they have their own, and they have the chokei knesset, etc. So it's not. It's also in many cases also it's not pishikol adas, which is also part of it.
But so I think it's political.
In that also, and but there are some who hold. There is a however a minority view who says that in this case they have the din of arkois shebisuria, which I'm going to explain soon. I didn't read it right now, but I'm going to explain what it is. In which case it wouldn't be such a big issue. But according to most poskim, they are categorized as regular arkois.
Some of the isurim that we mentioned at the beginning, why we shouldn't go to goyim,
Yeah.
doesn't apply when it's.
For example.
Yeah. All these things.
Yeah.
You
basically have to go deep. What's the reason that even to go to a person of Yidden that are not following Din and Torah is also forbidden?
So I'm sure it has less of the...
Yeah.
I was going to say in Israel, though, like, let's say you get a traffic ticket and you're going to go to court. You're the Jew against the Jew, but you have no option to go to Beis Din for this kind of court.
We'll talk about those cases later.
Yeah.
We'll talk about Yeah. But in where you said about being less severe, this Shalos Chuvas says vart fakert, that when it comes to Yidden who are following non-Jewish laws, it's even worse in a sense because goyim they're more definitely. So in Eretz Yisrael the same would apply. Number 3 that would apply here in Hay is this gather of arkois shebisuria. So what's arkois shebisuria? I didn't write it down, but I saw it later, so I just want to add. It's like a little bit it's like a mamen amuzgo, so to speak. So there's in Gemara and Sanhedrin there's a concept called arkois shebisuria, and it says that you're allowed to go to arkois shebisuria. So what's arkois shebisuria? So Rashi explains that it's talking about the Yonim Yehudim. They're Jewish judges. Elamai, they're not bikim. They're not bikim within Torah. They're not expert in the halachas of Torah. So you have 3 judges. They don't know all the laws, and they're just the bezin of that village or that city or that look. The Maaseh, we hold of that in cases when there's no proper bezdin. Danim ksherim. So
are they trying to judge on Torah?
Yeah.
They don't know, or they're just using their logic.
No, so that's the vart. The vart is that they want to judge on Torah, but the Maaseh they're not the Danim ksherim. They're not because they don't have the proper knowledge or. Yeah, so the halacha is that we do follow this svara in cases where there's no proper bezdin. In fact, it's actually better for you to go to this bezdin, which for some reason the Danim are not mumkin, they're not bikin in Torah, than to go to a secular court. It's worse. The latter is worse. So again, some want to say that in Eretz Yisrael these bati mishpat have this status of arkois, which is hard to understand. And again, I just want to emphasize that most poskim hold that the bati mishpat in itself have the status. They have the status of arkois shel goyim, which is forbidden to go if you don't have a shuz bezin, as we're going to get later. Okay, page 5, Vav. We're gonna have 3 more pages. Let's get through this. Messiah Yitzug Edus, some interesting details. 1. Call me Shabiyah the Limchis with Ibnoya, Yehudi Lolechas Lodin Makoshan Balchal Derek Shehi. High loss is that any person who has, in any case, has the ability to avoid or stop a person from going to a secular court, his fellow Jew, he has the chiyuv to do so. He has to do whatever he has in his power to stop somebody from going to the secular court. Number 2, also l'shum adam Yisrael l'sayeh l'teivdei chaver l'fnei hakohes mikol sheken shelo yatzeg oisei ve'le'abia tevas das miktuis v'kayetz b'zeh l'fnei gil b'kohes. It's forbidden for any person, any Jew, to assist any plaintiff to go to a secular court. So you can also not represent him in a regular court, and also you cannot give professional advice or any sort of help that he needs that's relevant to our lawyers on the table. So this is Benegir the plaintiff. Now liatzeg nitba, if it's the defendant, let's say somebody's already bringing because he's nothing. Can't do anything. Let's say Reuven takes Shimon to the court. If you're Shimon's lawyer, you're allowed to go help Shimon in this case because Reuven is the one who's taking. Exactly. And not only that, you're allowed to have as if you're saving an oppressed person from his oppression. Number 3, when a Jew takes his friend to a secular court, you cannot testify there without first getting a reshus from Bezdin. I guess this
So if you get a subpoena and you legally required.
In that case, I'm sure the
Bezdin
is going to give it.
But you got to bring it to Bezdin and get the reshus.
I believe so.
Yeah.
It's a very good question. I believe so. Yeah. Even though it's going to cost you to go to Bezdin in many cases. Just a few weeks ago, so a friend of mine asked me. He was dealing with some real estate with his partner, and his partner ignored his terms and conditions. So he wants to take him to. He's a Jewish person, but he wants to take him to secular court. He doesn't want to take him to Bezdin because if he takes the Bezdin, his partner would have some advantages because he can prepare whatever in advance. He wants to kind of surprise him and take him to a secular court. So he had to go to a Bezdin to get a reshus to take him to secular court. And I asked him how much did it cost just to go to a Bezdin.
Just to get the reshus pass, man.
A few hours, yeah, a lot. But he said that they also see what your case is worth. So because it's real estate, he's finding for that much. So a little percentage of how much they can take. But it's
Yeah, if you're a poor man and you have to go to
depending on the
jail, maybe they'll charge
yeah. I assume so. Yeah. Now it's an interesting rule that many times we have financial disputes when you can only take it away with advice. Going to meaning whenever the case is that the Bezdin gives a heter, so that's a mitzvah to go testify in a court. That's in a nutshell what this means. Number 4, let's say you have a guy, and the guy is having a case against a Jew, and now this guy wants you to go testify for him. For whatever reason, he's your boss, whatever. So in that case, there's many details, and a person should ask an expert in the field. Okay, again, so if a guy wants to hire you or call you to testify against a Jew, it's not so simple. Zayin.
So basically, like, getting back to this, so basically the same situation, like let's say for like here we have like the rich de logement, where you can't, it's not the same. Like you can't even go. You have to go there. You can't even go to like a normal court to like get a judgment for this type of real estate property stuff or rentals.
Right.
So you would have to then, if you're taking another Jew there, you would have to go. You're saying go to the Beis Din, say, can I take them to? They'll obviously allow it because they can't settle on these matters. You're saying you first have to get the approval from Beis Din.
Not always. There are some cases we'll see later. There's an exception. You don't even have to get just from Beis Din. And mainly the most famous cases in this kind of the disputes when the only option is to go to the secular court. So in those cases, you don't even have to go to a Beis Din.
Won't even look at this case.
Correct.
It's only this one little department to look at
Correct. In those cases, you don't even need to go to Beis Din. Okay, there are some exceptions.
Those cases being that
the secular court would not enforce the judgment of Beis Din. So if
Yeah.
you get a judgment of Beis Din, there's no way to.
Correct.
Yeah.
Correct.
That's
That's also another point. Yeah.
That's a good
Or
point.
does Olamais, if you think about it, I forgot to mention this. Nowadays, the Beis Din has very little of how much they can judge on, because we don't have any more the smicha of Eretz Yisrael, and so it stopped. For example, Knossos and many other things, and Oynesh and many other little details that the Beis Din nowadays doesn't have the power to do. So in most cases, I believe, when it comes to financial dispute, you will see. Not in most cases, but very often you'll see the Beis Din giving other shoes to somebody to go to a secular court. Mishet is my asset. So now we're talking about what do you do? Let's say you're a defendant and your fellow friend summoned you to go to a secular court. What are you supposed to do? So Adam shows me no. You have to go there immediately to a Beis Din. You should go as a defendant to go to a Beis Din to seek advice. You have to go. You have to go to the Beis Din and ask them to call the plaintiff to come to Din Torah so that he can remove the case from the secular court and deal with the case in our court.
Basically, ask for an order that he drops the lawsuit.
Yeah, exactly.
Yeah. That's how it works, I guess.
Yeah.
And if he does not do that, so if a defendant does not go to Beis Din right away and he doesn't show his interest of dealing with this case, it shows that he doesn't mind going to secular court. And therefore he's considered that he's Sayer Dvar Avera, because at the end of the day, the plaintiff is an Avera, even if he's not doing any action. But if he goes to a regular Beis Din, in that case, he's gonna save himself and his friend from doing an issue.
Did you mention about a lawyer?
But they get what?
No, the dogma, if a Yid calls you that they wanna same thing.
Yeah, you have to get advice from the Beis Din.
Yeah, interesting. Stop. So you get that someone's taking on you to court without permission of Beis Din. They want to hire those as a lawyer.
Yeah. And we mentioned earlier, but again,
You ever had the situation that you had to decline because of that?
Jews don't fight. Yeah, for sure.
Even what?
Even on from Jews.
So I'm thinking of one case where, in retrospect, I should have.
In hindsight, you should have.
But they wouldn't. They would have looked at it like crazy.
At least you get a shoes from Beis Din. That you another advantage of doing that, of going to Beis Din, that if he goes to the Beis Din first, he also gets the advantage that later on, any expenses that he had because of the secular court, he can claim now from the plaintiff. For example, lawyer fees or any other similar expenses that the defendant had to incur because of this issue, he can now have to be, even if he goes to Beis Din and now the Beis Din is aware of the situation, he has the power to claim that money back from the plaintiff. Through Beis Din.
So if the plaintiff doesn't come in, acknowledge the Beis Din.
I understand, but then the Beis Din has the power to put him in either, etc. Whatever. Like, if a person doesn't choose to go to Beis Din right away, as we mentioned earlier, in that case, all the fees all the expenses that he spent, he not necessarily would be able to retrieve those. Because he didn't go to Beis Din right away. However, the best case scenario is for you to go to Beis Din right away. But if it's in a case, if time is of essence, for whatever reason he doesn't have enough time to go to the Beis Din first, and there's a chashash, there's a doubt, there's a chance that because of him delaying, he could be punished either through fees or through the case being
Default judgment.
Yeah. In that case, he can do whatever he needs to protect himself, even without interest from Beis Din, because then he's going to lose something. If he doesn't have time to go to Beis Din, lives in a place and there's no Beis Din, whatever the case is, he doesn't have access to the internet.
How long would it take? Beis Din Montreal.
Same day. Most cases, I would say,
You show up.
they look at the case and they, I guess so. I can't answer. But usually when you get a case, you have a few weeks to prepare yourself.
That's what I'm wondering.
Right. It's a good question.
I'm going to wait many times.
I'm assuming Bichlal, a defendant also.
Like about 40 days later is we bring it to Bezdin, and 40 days later is when we get a notice, and about 40 days later we actually.
The Bezdin?
Yeah.
Oh,
For the trial?
The trial.
Oh,
Like 10 times faster.
400 days.
No, it's very fast.
ושכנגדו חייב לשלם מהיר את סויס על כך, כגון הגש כסף הגונו, או לשלוח עורך דין מטעמי וכל כיוצא בזה. Okay. So, okay, we're done with that. Ches. So now we're going to answer some of the questions that were asked throughout the class, which is, Imosei Bezdin Matirin Lifnei Arkois. When do Bezdin permit going to Arkois? Misha Baldino Alom, the Savan Militias, the Istavana Bezdin, the Sudu Shadalim, the Savan of the Nechem, Yitub Shubeden, the Mankoy, Rakakach, Yochel Tveretzum, the Simon and the other. We already saw this halacha. The person is dealing with a stubborn person, he does not want to go to a Bezdin. In that case, you go to a Bezdin, get a shus, and you can go to a secular court. So what's the reason for it? Why is it allowed? So the Sam Sefer Findus writes, "Shekasher hoylech b'shus Bezdin ari ein zedik shedon b'fnei Arkois atzmam, elandav nikol shem dayon yisov shedisinat shus adiyadam ein elo letzerich atzaz monek sheyev shebefnach." Meaning, the Sam Sefer explains, in this case, doesn't mean that at the end of the day you're doing the din through the secular court. It means that because the Bezdin gave you the shus to do so, it's as if the whole din is going out the Torah. So that's a lot. It's just the perspective of how to look at this court case. Number two, cause of placing Shahat.
The board of Bezdin or Chachamim,
They have the power.
the power to change.
Yeah.
Change the Metzias and belt.
Yeah, that it says it's going up Torah, but whoever's judging is the secular court. Cause of placing Shahat Lechas Lakoy historically nothing me ace bad is just flesh of Davka. Because in Allah, there's a whole discussion of when do you need a Bezdin of one Rav or when do you need a three. In most cases, you need a three. This is one of them that you need a Bezdin of three in order to get a reshus. Furthermore, it's appropriate if the reshus is given in writing. It's also, I guess, better for you just to have a document that you got this permission. Number three, going במשרד ממשלתי או לחברת ביטוח וכזה, יש פעמים שאין צורך לבקש רשות מפנסיה. So like we mentioned earlier, that in cases when we know for certain that the case can be brought to a Bezdin, for example, insurance companies or any similar cases where you're dealing with local laws and you have to go to secular court in order to deal with the issue. So in that case, many say that you don't even have to get a reshus from Bezdin, you just can go straight to secular court when it comes to tenant landlord, this kind of things. And now there's an interesting addendum that if it's talking about two individual people and they're having a financial dispute between themselves, even if it's a non-from yid, as of now, he does not want to go to Bezdin. Nevertheless, see, you have to go to a Bezdin first before you go to the secular court. But some are making. You should still, at the very least, speak to one dayan about this situation and find out how to approach the case and see if anything needs to be done before you take somebody to court. In that case, when it's a non-Jewish, non-true person.
That would apply for a client who wants to sue another non-Jew.
Exactly. It would apply in that case. Yeah. See how to take from there. Sometimes you might need to go to three people, or sometimes he's going to tell you don't need it at all. You have to basically ask a shayla. Number four, that's your question earlier. To go to a secular court in order to enforce the judgment that was done by a Bezdin. It's also one of the cases we don't even have to get this from Bezdin because you already won in the Bezdin. You just can go now to second. May I take this case to the second? Number five, Aldvar Yad Akol Tkefa in the 8:2 where we spoke about this. We didn't speak about this. Anyways, next time. All right. Do we have another 10 minutes? Or okay, so let's skip tests and let's just go to the yod, which is the most important part. basically I did some research about places sichas where the Rebbe speaks about the custom of Lakayas, and I selected 3 of them. These are all from the year Tafshin Chavtes, and they're each in different falakim.
That's a good say the kid, the Nekuda.
The Nekuda is basically in Simon Tes, Ois Tes, we're talking about it plays a role into what we're discussing in like cases where are you allowed to inform to the police, or and then they eventually bring to a judgment any person who's dangerous to a community, like somebody who's has allegations of whatever you want to imagine. Huh?
Someone who knows disgusting things.
Yeah, somebody who doesn't behave accordingly, or even a person who's drives negligently, and or he goes the people's life at risk, and there's a communal.
So yeah, people are responsible for their own.
Yeah.
Dangerous for themselves.
Yeah. Everything. So in all these cases, there's many people. Yarchei Kallah, a person cannot be moister to the police, but in all these cases when it's a mamish of nefesh and it's for the big communal cause, there's many kulas to that a person would be able to
like come into effect. Say you have to go to Best Stand and then get like approval before you call.
So in many cases you don't have to. Yeah.
Lose the time. I'm saying
So that's the part. Yeah, the part is that in many cases you don't even have to get the shoes. It's already they already wrote down a list of cases when the law is you don't have to ask. You know already that if of course this is the only option and the person has proven dangerous and now this is the last resort, so you're allowed to be moister on them, so to speak, in order to save for the better good. So it's true that I quoted some parts on Sichas where the Rebbe speaks about the Kais. They're interesting things, so let's go through them. But first, Pasha Mishpatim, Tafshin Chavtes, the Rebbe says, this is interesting because the Rebbe quotes Eicha Rabba. That's why I kept the number 58 here. It says in the Medrash, Aval Pisheish Chachma Begoyim Tamin. Hine Yesh Teda Begoyim Al Tamin. Meaning, it says in the Medrash that to say that the Yesh Chachma Begoyim, if a person says that the non-Jews, they have chachma, they have wisdom, so that's you can believe him. Yeah, they do have wisdom, but to say that they have Torah, don't believe such a person because it's hefech Torah, and that's one of the reasons why we can't take a case to a secular court. And he adds over here, Loi Maspik. I'm reading the highlighted portions. Loi Maspik being an chitzonis b'levad, elo tzarich is gam inin of primis. That it affects also the primis of you know. Now, in Achon Shepesach Tafshin Chavtes, a few weeks later, the Rebbe says, the Rebbe says that through going to secular court, you, at the end of the day, you're adding strength and koyach to Umay So'ilam, and you're diminishing the koyach of Yisrael. Well, then, like the Chazal said, the Pasuk Ve'ed Mishpatim, Alta V'yu Merkosh Alhem, V'chulu, and the Rebbe concludes by saying, Kadesh Le'lo Koyach. Finally, number 3 here, Pashas Sheftim, base Elotat Shel Chavtes, the Rebbe says as follows: V'hinin Zeh Kosher Mameduba Berich Al Acharina She'asur LeYehudi LeYisyare Migoy. This is a proposal for the times that we're living. A person, it's forbidden for a yid to be afraid of a goy. The Im Yehudi Misyare Migoy. The Rebbe says if a yid he is afraid from a goy, Harehu Moisef Koyach Tetzel Goy. Then and day he's adding koyach to the goy, and that shows on a pasuk. The Rebbe says brings the pasuk lifnei v'lifnei Yaakov. Afilu yeah, call me shemaniach edin so lifnei Yaakov kafar b'kadosh baruch hu tchila v'chariken b'tera shemar kilei kitzulenu tzura v'gen plirim. And this is a lesson for the days that we're living, especially this week, with all the threats and all the concerns. We should make sure that we are not afraid of the goyim. That we have made a sasam of simcha. Yulam tizashtema. Okay,
we'll have a seal now. Yossi Doron, Masechet Ksubis.